Hi, my name is Sharmeen Anwar. I'm an attorney with the Cobb Legal Aid. I'm also the attorney in the Law Library. I provide free 30-minute consultations every Monday through Wednesday from 9 a.m. to 4 p.m. And today I will be giving a presentation on unemployment insurance benefits. This is just a general overview with an emphasis on the appeals at the appeals tribunal level. So, what are unemployment benefits? They're basically cash payments to eligible claimants who are no longer employed through no fault of their own. Unemployment benefits come from an unemployment insurance trust fund, which is funded by taxes paid by the employer. Who is eligible for benefits? So generally, you need to have earned sufficient insured wages. And what that basically means is that you must prove earnings in at least 2 base period quarters with combined earnings of at least $1,134 in 2 quarters when you receive the most pay. Your total base period pay must equal at least 1.5 times what you earn in the highest paid quarter. And that's very complicated language, but thankfully you don't need to figure that out yourself. The Department of Labor figures that out. And if you are curious to know how they calculate that, there is a really great handbook on the Department of Labor's website, and you can take a look at that. There's also a breakdown of how the Department of Labor calculates that under their frequently asked questions. So if you would like to know more about how insured wages are calculated, you can take a look at that. You must also show that you have job separation from your last employer due to no fault of your own. You must show that you have lawful presence in the United States, and you must be ready, able, available, and actively searching for work. And we'll talk a little bit more about that later. And something I'm going to talk a little bit more about later on, but I want to just touch upon this, is does resignation count? So could you still get unemployment benefits if you quit? And yes, under certain circumstances, you can get unemployment benefits if you quit. Generally, you must show that you resigned or quit for good work-connected reasons, which can include a material change in working conditions, a material change in working agreement, non-payment for work, or other similar reasons. And again, we'll talk about that more later on. Okay, so what does the application process look like? It's fairly straightforward. You can apply by 2 methods. You can either go to a career center and fill out the paperwork, or you can complete an application online. Most claimants will do it online, as it is just far more simple to do it that way. However, I think that you do not have the online method available to you if you recently moved to Georgia and you have not worked in Georgia, but you would like unemployment benefits because, let's say, you were recently unemployed from where the state you moved from. In that situation, you would have to go to a career center and fill out an application in person. At the application point, you don't need to present a separation notice, and we'll talk a little bit more about the value of a separation notice, but at this point, you really don't need to provide it. You do just need to basically have like your ID available, your social security number available, because that's the information they want at that point. So let's talk about what happens when you filed your application. You're going to get 2 determinations. The first one is the unemployment insurance benefits determination, also known as the monetary determination. This letter tells you whether or not you have enough earned wages. And then you're going to get a second letter called the claims examiner's determination. And this letter actually tells you whether or not you were approved. This can be very confusing because I will have clients who will tell me, I was approved for benefits, and then all of a sudden I got a letter saying I'm not. What happened? And that's because the monetary determination will tell you if you have enough wages, and that can be confusing because if you're getting a letter saying, hey, you have enough wages, you're going to think, okay, great, I get unemployment benefits. But that's not where it stops. You have to wait for the claims examiner's determination because that's going to tell you whether or not you meet those other requirements, like did your employment end through no fault of your own. So that just be mindful that the monetary determination is not the final determination. You do need to wait for the claims examiner's determination. Importantly though, if the monetary determination is inaccurate, let's say it leaves off maybe one of your employers. So let's say you worked somewhere and it's not reflected in the monetary determination, you can absolutely appeal that decision. And at the bottom of the monetary determination letter, it actually tells you that I believe it's that you typically have 15 days to appeal, and it'll tell you how long you have and when you need to appeal by and how you appeal. Importantly, the appeal timeline starts from the date of the determination letter. It's not from when you receive the letter. And that's the same thing with the claims examiner's determination. If you were denied benefits, then you need to appeal from the date of the letter on the claims examiner's letter. So if you were approved benefits, great. That's basically what happens is you're gonna get benefits either directly deposited into your bank account, or you can opt for a card, kind of like a debit card, and they'll put your benefits in that. The minimum weekly benefit is $55 and the maximum is $365. The amount that you would receive is based on the amount of wages earned in the base period, and we just don't have enough time to talk about how that's calculated. But again, the Department of Labor's website does give a breakdown of these things, so you can definitely look at that. And be mindful that just because someone is receiving $100 doesn't mean you should also be getting the same amount. It's a very individualized assessment. Georgia regulations allow claimants to receive up to 26 weeks of unemployment insurance benefits. Importantly, you must continue to certify, and certifying is basically the process of letting the Department of Labor know that you are actively looking for work, you're able to work, basically reflecting what your job search is. So you must do that so long as you're unemployed and so long as you would like benefits. So what happens if you were denied? So you get that claims examiner's determination letter and it says, sorry, you don't qualify, you're denied. Well, as I'd mentioned before, you can appeal the decision, and you have 15 days from the date of the letter to appeal. In the appeal, it's actually not as onerous as maybe you may think. What they're really just looking for is your name, your social security number, the decision being appealed, your address, phone number, and this has to be the best number that you can be reached at. Make sure it's a current number, and we'll talk about why that's so important later on. The date on the determination or the decision, and then you need to also identify like the exact determination or decision you are appealing. Remember, you could also appeal the monetary determination, or you can appeal the claims examiner's determination. And you should explain in detail why you're appealing. This, like I said, it can be a pretty quick summary of why you disagree with the Georgia Department of Labor's determination. It doesn't have to be this long, drawn-out explanation, just a quick summary highlighting why you think you should get benefits. At this point, you do not need to submit any evidence. You do not need to attach any documents. You will be given that opportunity if a hearing is scheduled. So don't worry about anything like that. It's a pretty short and simple process. Now, the methods to appeal. There's 3 primary ways you can appeal. You can do it online by going to the website. You could do it by email or fax. If you go online, there's basically a whole process where you're going to have to like click on certain tabs and follow their instructions. I personally advise clients to just appeal by sending an email, primarily because it's typically the simplest way to do it. Also, there's a really easy way to refer back to your appeal, because you can just go back to your email, look at your sent box and see, oh, I sent this appeal on this day at this time, and this is what was in my appeal. This is important because let's say you never get a hearing scheduled, or let's say there's some issue about whether or not you filed an appeal. Well, if you sent it by email, you could easily just pull up the date and timestamp and show, nope, I did submit it. It's also helpful for attorneys because let's say you filed your appeal when you weren't represented, but later you do retain counsel to represent you at the hearing. Well, your attorney is going to want to know what you put in your appeal. So the email is a really great way for you to just quickly access it and give it to your attorney or for you to refer to before your hearing. You could also fax it, but again, I prefer email because that is the simplest way to do it. Okay, so as I'd mentioned, there's multiple levels of appeal. We really are going to be focusing on the appeals tribunal because that's the first level of appeal, and that's the one where claimants and our clients typically are facing and need help with. So what you're going to get while you're waiting for your hearing, you're going to get basically the notice of appeal filing. So this is basically a packet of all documents pertaining to your claim. It's going to include whatever the employer may have sent to the Department of Labor when they were making their initial determination. It may also include your separation notice. This is really important because your employer is required to give you a separation notice, but often you don't get it. Having the separation notice is evidence of why you were let go. And often we'll see that an employer, when they give you the separation notice at the time of termination, they may write something like lack of work. But weeks later, if you've applied for unemployment, they may end up telling the Department of Labor that you were let go because you broke a rule. So that inconsistency between the separation notice and what they told the Department of Labor creates doubt, and it weakens the employer's credibility. So make sure that when you get this notice of appeal filing, that packet, look for the separation notice and see what they told them. What evidence did they give the Department of Labor? That will really help you. You'll also get a hearing notice, and this is very, very important. It's going to contain the date, the time of your hearing. All hearings are in Eastern Standard Time, so if you happen to be out of the time zone, just be aware that it's going to be in Eastern Standard Time. And it's also going to list the numbers that will be called, because pretty much all hearings now are telephonic. You could request an in-person hearing under certain circumstances, like you need some kind of accommodation and you can't do it by phone. But pretty much all of them are by phone. And so you really want to review the hearing notice carefully, because the number on that hearing notice is the number that the Department of Labor will call for the hearing. If you do happen to retain counsel after the fact, there's instructions on adding your attorney's number, and it's your responsibility as the client to add the attorney's number to the hearing. So it's going to have the date, the time, the numbers, and most importantly, it's also going to have the issues to be decided. So your hearing isn't just going to be an open forum to talk about anything and everything that happened at your place of work. The hearing officer is going to tailor the hearing to the specific issues listed on the hearing notice. And I cannot tell you how many times I've had clients completely miss this, because it's typically on the back side of the hearing notice. So they'll look at the first page, they'll say, okay, it looks like it's this day, this time, these are the numbers, and then they'll completely miss the fact that there's a backside to it. I would want you should really carefully review the hearing notice's issues to be decided, because it will cite the law. And when you're doing your preparation, you're going to want to review those specific provisions of the law. So make sure you pay really, really close attention to the hearing notice. What we can also talk about a little bit is about postponing a hearing. So let's say you want to, you're saying, oh, there's a conflict, I can't attend the hearing, can I postpone it? It's kind of tough to postpone the hearing. You're going to have to basically show that there's some kind of emergency, unforeseen, unexpected event that is preventing you from attending this hearing. Because keep in mind, these hearings are telephonic, so the Department of Labor expects you to be able to attend it. It's not like they're in person where there are added barriers to attending it. If you do need to postpone it, some of the reasons that may be permissible is, for example, let's say there's some unforeseen illness resulting in hospitalization, if there is a family death, if you have military duty or jury duty, basically something that's kind of out of your control and a bit unforeseen. And one thing I really do want to highlight before we move on is even if you have an appeal pending, so even if the Department of Labor denied your application, you should still continue to certify even while the appeal is pending. Because if the Department of Labor ends up approving you for benefits, they're only going to approve you for the weeks that you actually certified. And that's why you need to make sure you're doing it as long as you are still waiting and you're still unemployed. Okay, so preparing for the hearing. Interestingly, you don't need representation. You don't even need an attorney to represent you at the hearing. You could have really a duly authorized agent, or you could represent yourself. One thing though, at least, Cobb Legal Aid, and we do assist individuals in their appeal hearings, but we usually request that you contact us as soon as you file that appeal, because usually you get the hearing notice about a week before the hearing. That doesn't give you much time to speak to an attorney and see if that attorney is available. So no matter what the situation is, if you feel like you may need an attorney, you should seek that help as soon as you file that appeal, so that gives enough time to investigate the claim and possibly represent. Yeah, it could be an attorney, you could represent yourself, it could be a duly authorized agent. For example, employers won't sometimes send their counsel, they won't send their attorney, and they may just send HR or someone like that to represent them at the hearing. So legal research. The relevant law is the Georgia Employment Security Law, and it's OCGA 34-8. You should take a look at it. The hearing officer will go over the relevant law and regulations that pertain to your case, and the hearing officer is familiar with the law, but still for your, to set yourself up for success, you should review, this particular part. And at the very least, you should look at the provisions that are cited in your hearing notice. I'd mentioned, the issues to be cited, they always cite the specific part of the law that they're deciding. So you should review that ahead of time, print it out before your hearing so you can quickly refer back to it if you need to. So gathering and submitting evidence. So, a few slides ago, we talked about when you apply, I said you don't need to submit any documents because you'll get a chance later on. This is your chance. So you should gather whatever documents you have. You should talk to whichever witnesses you'd like to possibly testify during the hearing. Importantly, you should try getting your evidence together as soon as you file the appeal, because as I had mentioned before, you may have about a week's notice before your hearing. And if you do plan on submitting evidence, you have a responsibility, an obligation to also submit those documents to the opposing party and the Department of Labor. I usually say 48 to 72 hours before the hearing. So if you think about it, if you wait until you get the hearing notice to start getting your stuff together, you may not have enough time to give it to the opposing party in the Department of Labor. And so if you show up to the hearing trying to enter in some documents into evidence, they may object to it saying, I never got this, or I didn't get this in a timely fashion. So make sure you start going through your documents, gathering all your evidence as soon as you file that appeal. As I'd mentioned, you do need to send it to the opposing party and the appeals tribunal. What I think is best practice is if you do plan on submitting some documents, you should create that packet, first email it to the opposing party, and then print out the email that shows that you already emailed this packet to the opposing party. You take that printout and you add it to the packet you're going to send to the Department of Labor as evidence that you actually did send the documents you want to use during the hearing, that you sent that to the opposing party. And I do that because, let's say at the hearing, the opposing party objects to you referencing a particular document, and they'll say, objection, I never received this document. But at least you have that email printout showing, well, no, I actually did submit this. Here's proof that I emailed this to them. This is the date, this is the time, this is what I submitted, and this is who I submitted it to. And then if you include that in your packet to the Department of Labor, the Department of Labor already has that email. So it will help kind of protect against those kinds of issues. So that's kind of just a general, rules about gathering and submitting evidence. One thing I do want to mention is if you do need some documents that, let's say, the opposing party isn't giving you, like let's say you're like, I really need my write-ups, and the opposing party is just being unresponsive, not working with you, you can subpoena them and you can have them produce those documents. And there is a whole process of requesting or subpoenaing the other party, and that is available on the website. So there's a whole handbook that you can also use during your preparation. All right, so the next thing we're going to focus on the types of claims. So basically, what are the most common claims that are heard during the hearing, right? Like what is your claim being classified as? And the most common are layoffs and furloughs, quit cases, and discharge. So, layoff. Even if you were laid off due to lack of work, you can get unemployment insurance benefits. But the important thing to keep in mind is severance, okay? So a lot of times you see where an employer will lay someone off due to lack of work, but they'll give them severance. And if that severance is more than the weekly benefit amount you'd get for unemployment, you cannot get unemployment. But if it's not more, then you could possibly get unemployment benefits. So you should keep that in mind, and you should report that. You should bring that up, because if you don't, and it looks like you get approved for unemployment, but then the Department of Labor later finds out that you actually got severance, you could be hit with an overpayment, and that's not something you want to deal with. Even if you get severance pay, you could possibly get unemployment if your severance runs out and you're still unemployed. So discharge. This claim is the most contentious one that we often see. Discharge, basically, where you can still get benefits. So a claimant is still entitled to benefits unless the employer proves by a preponderance of the evidence that there was intentional misconduct or conscious neglect of job duties by the claimant. So this burden of proof is on the employer. The employer has to show that you intentionally engaged in some kind of misconduct or you had a conscious neglect of job duties. And the employer has to show that you were at fault and that the fault is attributable to the claimant for disqualification. And they must also show that you or the claimant was at fault in the final incident that led to the termination. So it's not just kind of like any kind of misconduct. It has to be intentional. It has to be something that you can point at the claimant and say, this was their fault. Fault is not where a claimant fails to meet the employer's expectations despite their best efforts. Fault is not where a claimant failed to follow an inconsistently applied rule. And I want to take a moment to talk about this a little bit more. So sometimes employers may, have a rule that they just don't follow regularly, consistently. So for example, let's say that there is a rule to always shred confidential information within 5 days of receiving it. And let's say the employer just does not follow that rule all the time. But one day when you didn't follow that rule, when you forgot to shred the confidential information within the time period, they decide to let you go. Well, you can try to show, hey, you know what? This rule that I broke and led to my discharge, they never even consistently followed it. So how could I have even had a reasonable expectation that I would have even been let go? Another thing I want to sort of touch upon is sometimes when you see like inconsistent rules applied, you may look at, well, is this rule only being applied to people of a particular population? And are those people only being penalized for not following that rule that's inconsistently being applied? there may be some evidence or hints of employment discrimination. So sometimes you do find that unemployment benefits cases kind of go hand in hand with a possible employment discrimination claim. At that point, things can get a little tricky. There's some civil procedure rules that come into play, some evidence rules that come into play. So if you feel that your unemployment claim is going to be touching on a lot of employment discrimination, possibly, you should definitely consult with an attorney because things can get tricky at that point. And the next one, fault is also not where a claimant is absent due to illness and followed the employer's policies and procedures. So for example, if you are sick and you can't come to work, but you followed, the employer's process for calling in sick, then that's not really your fault, right? But let's say you were sick and you're absent because you were sick and you didn't follow the employer's procedures and policies, well, there's some evidence that perhaps you were at fault, at which point you may not be able to collect benefits. Another thing intersection I want to talk about when it comes to illnesses. So we often find that there's sometimes tends to be an intersection between disability law and unemployment. So remember, if you are asking for unemployment benefits, you are certifying every week that you are ready and able to work. But what happens if someone, got discharged because they were sick and then that sickness turned into some kind of disabling condition? Well, then you come across this issue of, can I certify that I'm actually able and actively looking for work if maybe my condition or my illness is now kind of developed into a disabling condition? So that's also a really tricky area of law. So if that's something that's going on, you should definitely speak with an attorney to kind of figure out how to navigate that. And finally, the other type of claim we see is like a quit situation where an employee quits. And we sort of talked about this before in the very beginning. Claimant is still eligible for benefits if they prove there was a good work-related cause for them to quit. Now, the key words are good work-related. It cannot just be any reason. Like, you could have a good reason for quitting. For example, maybe you get married and you're moving to a different state. That's a good reason, right? But it's not a work-related reason. So you have to show that the reason you quit was good and work-related. The action of quitting must also be voluntary. So it has to be your choice, essentially, to quit. And something that we see sometimes is an employer may call an employee into the office and say, you know what, we're going to have to let you go, but we're going to give you the option to quit because obviously resignation may look better than a discharge, right? This is tricky because is it really voluntary at that point if you're kind of being told, well, we're going to let you go anyways, right? Is it really voluntary? And this also kind of matters as far as burdens of proof and evidence, like what you have to produce evidence-wise, because if you quit technically, well, then your claim is going to fall within this bucket and this burden of proof, and that's what the hearing officer is going to be looking at. But if you're discharged, as we talked about before, it's the employer's burden of proof to show that you were discharged for intentional misconduct. So you have to show that this was actually voluntary in order to be able to get benefits. And as I'd mentioned, good work-related causes include material change in terms and conditions of job, claimant's health adversely affected by work conditions. Fleeing domestic violence is also, maybe it's unexpected for someone, but that is definitely a reason why you could possibly get unemployment benefits. What we can talk a little bit about what does a material change in terms and conditions of job look like. So let's say you started a job in downtown Atlanta and you depended on the public transportation to get there because you don't have a car. But then maybe the job changes the conditions and has you go all the way up north Georgia where there's no really great public transportation for you and you don't really have a great way to get there. Well, arguably that could be, material change in the terms and conditions of the job. So you could possibly try to get unemployment by saying, well, I had a good work-related reason for quitting. Discharge versus quit, that's something I already kind of talked about. We want to make sure that your claim is being classified correctly. Okay, so let's talk about the hearing itself. Again, you don't have to be an attorney at the hearing. You could represent yourself, so it's not necessary. But like I said, if you feel that you may need an attorney, you should consider reaching out to the Cobb Legal Aid. Of course, eligibility requirements, apply here. As I'd mentioned, most hearings are telephonic, so let's talk and let's focus a little bit more about the telephonic hearing. You should definitely make sure, like I said, that they have the correct number for you. You should make sure your phone is charged. You have a charging cable near you in case your phone dies, but it should be charged all the way. Try to go to a quiet, isolated area where there's not a lot of background noise, because sometimes a hearing could just be halted, like stopped, because there's just too much background noise or they can't hear you. Make sure you have good cell service as well. Make sure you have any documents that you want to use during the hearing. You have that printed, ready to use. You have the hearing notice in front of you. You also have the notice of appeal filing, which is all the documents. Again, if the opposing party sent some documents, make sure you've already reviewed those thoroughly. And if you do have objections to them, you should bring that up at the hearing. Just have everything printed out, ready, easily accessible for you during the hearing. So something people always ask is, well, what's the order of the hearing? Well, it depends on the type of claim and based on burden of proof. Employer goes first in discharges cases, claimant goes first in quit cases. If you have an attorney, it just depends on what that particular officer may want. I've been in a situation where an officer will say, counsel, it's your attorney, your witness, and then I will question back and forth. Some officers may just start asking the claimant questions right away. Some officers may allow the claimant just to kind of talk broadly about what happened and openly about what happened, and then they'll narrow in on some issues and they'll ask those questions. So it's hard to say maybe what the exact the way it would look through the hearing. But you will get the opportunity to question the opposing party. So make sure that you have those ahead of time, and make sure you pay attention when the opposing party is testifying. Make sure you're paying attention and have a notepad ready so you can jot down notes and be like, I want to ask him about this, I want to ask him about that. So you'll get that chance to ask. You will also get the chance to have closing statements where basically you summarize your case. In this, you also want to include, while I'm not just including my summary of my case, but you want to hit on those issues or those points that the opposing party was making. So if they're trying to make certain points, you want to hit on them and undermine them and say, well, this is why those points were wrong. So you want to have a good closing statement. Something that we just don't have a lot of time to get into, but the rules of evidence apply in the hearing. So something like hearsay definitely applies. And something we do tend to see is the employer will send someone like an HR personnel who has no personal knowledge of anything, and they're just reading off of some notes that they didn't even really take. In that case, you could just object to the whole testimony at that point, because it's really just hearsay. What does the HR personnel personally even know about the case? So you want to make sure you object to it, because if you appeal the decision, the higher levels will take a look that you actually did object to a particular testimony or evidence or something coming in. So what's next? After the hearing, and I will mention the hearing typically lasts about an hour. So that's about the average time. So what's next after the hearing? Well, a decision will be issued. Usually within a week or two after the hearing, you'll hear back. It'll be mailed to you and the opposing party. And if you unfortunately are not happy with the decision, if again you're denied, you can appeal to the Board of Review. And again, if that's denied, then there's the Superior Court. And if that's denied, then there's the Georgia Court of Appeals. So there are higher levels of appeal, and we just don't have the time to go into those, what that exactly looks like. But there are further appeal levels, and the Department of Labor's website and handbook does kind of touch upon what you need to do for each of those. Oops. All right. So just to close up, if you do so just to close up, if you do find that you need help, this is the contact information for Cobb Legal Aid. You could call us to do an intake. Those are our intake hours. Again, I am the lawyer in the law library. I provide free 30-minute consultations Monday through Wednesday, 9 a.m. to 4 p.m. I'm located on the 4th floor Cobb Superior Court in the law library. And of course, eligibility, applies. So eligibility requirements apply not just for Cobb Legal Aid, but also for a lawyer in the law library. Thank you so much for attending this training, and I hope that it was helpful.